In this episode, I would like to discuss about section 124 of the Indian Contract Act 1872, that is definition of the contract of indemnity with its limitations. Now, section 124 of the Indian Contract Act 1872 deals with the definition of the contract of indemnity, but it is said that definition of the contract of indemnity is narrow one. That means, there are some limitations in the definition itself, for which we can say that the definition is not broader. That means, every aspects are not covered by the definition of indemnity itself. Now, section 124 deals with only about expressed indemnity. Apart from expressed indemnity, there are other implied indemnities which are not covered by section 124 itself. So, there are some other few sections I would like to discuss over here in a brief manner, like section 69 of the Indian Contract Act and also section 145, 222 and 223 of the Indian Contract Act. So, section 124 defines the indemnity, section 69 reimbursement of the person, and section 145 implied promise to indemnify the surety, section 222 agent to be indemnified against consequences of the lawful acts, and 223 agent to be indemnified against consequences of the acts done in good faith. So, if we consider these 5 sections altogether, that is section 124 definition, 69 reimbursement, 145 implied promise to indemnify surety, 222 agent to be indemnified against consequences of lawful acts, and 223 agent to be indemnified against consequences of acts done in good faith. If we consider all these 5 sections altogether, then we can understand that why the definition of the contract of indemnity is considered as narrow one. So, I would like to discuss each sections in a brief manner one by one. So, firstly, section 69 of the Indian Contract Act, which says about reimbursement of person paying money which is due by other, in which he is interested to make the payment, is to be reimbursed. That means, if the situation is such that one person is bound to make any payment in which another person is merely interested to make the payment and thereby pays the amount, is entitled to be reimbursed by the person who was actually bound to make the payment. So, Indian Contract Act section 69 has given one illustration that a person under the lease of another person is holding a plot of land. Now, there is the arrears of revenue. Now, government has given the notification that unless the arrears of revenue is paid, it will be sold out in auction. So, if that leasehold property is sold out in auction, whether the lessor will only suffer, lessee will also suffer. So, that is why lessee has paid out the bill, lessee has paid out the entire money which was due before the government, because lessee was interested, but lessor was bound to make the payment. Now, since lessee has paid up the money in which he is interested and ultimately in which lessor was bound to make the payment, now by virtue of section 69, lessor will compensate the lessee. So, whatever he has paid, the lessor will compensate. So, another illustration can be given that there is landlord and tenant in any premises. Now, electricity bill is in arrears. As for example, that last 6 months, 6 consecutive months electricity bill is unpaid by the landlord. Now, CSC has served the notice that unless the money is paid, electricity bill is paid within 15 days, the line will get disconnected. So, if the line get disconnected, So, only whether the landlord will not suffer, tenant will also suffer, because both are consuming the electricity from the common meter. So, in order to protect the interest, tenant has paid up the bill which was supposed to be paid by the landlord, because unless the bill is paid, both of their right will be jeopardized. So, tenant has paid up the arrears of electricity bill which was supposed to be paid by the landlord. Now, question is whether landlord is bound to reimburse the tenant of that bill amount, since there was no such express indemnity contract. Yes, by virtue of section 69 of the Indian Contract Act, the landlord is bound to make the payment to the tenant, because that is the concept of implied indemnity. Though there was no such express terms and contract, but still by force of law, by application of section 69 of the Indian Contract Act, landlord is bound to make payment to the tenant, because landlord ultimately in these circumstances was bound to make the payment, in which tenant was merely interested to make the payment and thereby paid the amount, is entitled to be reimbursed by the landlord. Now, I am discussing about section 145 of the Indian Contract Act, which discusses about the right of surety to be reimbursed by the principal debtor. So, in every contract of guarantee, there is an implied promise by the principal debtor to indemnify the surety. But one condition is there, that surety is entitled to be reimbursed by the principal debtor only the amount of sum what he has paid duly. If surety has not paid anything duly, that means if he has paid something unduly, that to that extent he is not entitled to be reimbursed. Surety is entitled to get back the money, to recover the money from the principal debtor, the amount which he has given on behalf of the principal debtor duly. Unduly portion he is not entitled to be reimbursed. That is the main theme of section 145. Now, section 145, here it is written that implied promise to indemnify the surety. So, A, B, C, there are three party tripartite agreement in case of contract of guarantee. Now, A is surety, B is principal debtor and C is creditor. What happens in this case? That it is agreed upon that A will stand as a guarantor and C will supply the rice amounting to rupees 2000, rice of 2000 will be supplied by the shopkeeper C to B on debt, and A is standing as guarantor. That means he will pay to C the rice of amounting to the extent of rupees 2000. So, A if made payment of rupees 2000 to C of rice, what C is bound to deliver to B. So, A is entitled to recover that 2000 rupees later on from the principal debtor if it is duly made by him. So, what does it mean? That C has supplied rice to B. If the quantity of the rice is equivalent to rupees 2000, then only A is entitled to recover that 2000 rupees money from B. But if C has supplied to B, as for example, the rice amounting to rupees only 1000, but C has secured rupees 2000 from Mr. A, surety, then later on A cannot claim rupees 2000 from B, because B received the rice actually not of 2000 from C, but of rupees 1000. That means there was less quantity. So, it is agreed that C will supply to B, that as per the contract of guarantee, the rice of amounting to rupees 2000, but instead of supplying rice of 2000 rupees, C has supplied to B the rice of rupees 1000. Now, but A has made the payment to C amount of rupees 2000. A cannot recover that 2000 rupees from B, because B got rice amounting to rupees 1000. So, that means A has duly paid to C only 1000, and another 1000 which A paid to creditor C, that is unduly. So, undue payment by virtue of section 145 of the Indian Contract Act, principal debtor is not bound to compensate. That means surety is entitled to be reimbursed by the principal debtor to the extent of the money what he has paid duly, not unduly. Now, I would like to discuss about section 222 of the Indian Contract Act. It says that agent is to be indemnified by the principal if he has acted in lawful manner. So, if any agent in pursuance of direction given by the principal has acted and thereby he suffered some loss, by virtue of section 222, agent will be indemnified by the principal if he has acted lawfully. Now, one illustration I am giving that over here, that B, A and C, B is the agent, and as per instruction of principal A, that B will supply some goods to C, he has entered into the contract. So, what happens? Agreement is made between B and C. C is the third person and B is the agent of A. Agreement is made between B and C that B will supply the commodity to C. Agreement is made in this way. Now, A has given the instruction. So, ultimately A will supply the commodities to B, what B will carry before C. But what happened? That A did not supply any goods or commodity to B. So, B failed to supply the goods to the third person. What happened? C filed a suit against B for damages. So, ultimately A, the principal, instructed the agent that you defend the case, and ultimately B defended the case, but as a result ultimately B was defeated and he had to pay the damages, costs and expenses. Now, question is whether agent is entitled to get back that money from principal or not. Yes, agent is to be reimbursed by the principal because he has acted in a lawful manner. First, agreement was made that he will supply the commodity and A given the instruction. Later on, A did not supply the commodity, and as a result third person filed the suit against B, and ultimately he instructed agent, you defend the case, and during that proceedings he was defeated and ultimately had to pay the damages, costs and expenses. Damages, costs and expenses. So, ultimately B, the agent, has acted in pursuance of direction given by the principal. So, A will compensate B, principal will compensate agent for his lawful act. So, A must compensate B the amount of damages, costs and expenses. So, finally, I would like to discuss about section 223 of the Indian Contract Act, which speaks about that agent is to be indemnified by the principal against any act which he has done in pursuance of the direction given by the principal in good faith. So, if the agent has done something in good faith in pursuance of the direction given by the principal, principal will indemnify the agent even though some third person has suffered some loss. So, even if the third person has suffered some loss, the principal is still bound to compensate the agent against the consequence. Now, I am giving one example, like here B is agent, A is principal and C is the third person. Now, A is the shopkeeper and B is acting there under the instruction of A. Now, some goods is already kept into the shop of Mr. A. Now, of that goods, A is not the real owner, but he instructed B to dispose of that commodity or goods as per his direction, and B has disposed of or B has sold out something. But later on, the real owner of that commodity, C, has come and C wanted to recover that good and money when C came to know that it is disposed of by B actually. Now, he filed a case against B and ultimately recovered the money from B. Now, A is bound to compensate that money to B, because B has acted in good faith in pursuance of direction given by the principal. So, the goods which was disposed of by the agent B in pursuance of the direction of A, though A was not the owner, ultimately C, the third person, was the owner. So, because of the disposition, ultimately third person C suffered the loss and thereby he recovered the damages from the agent B. Now, in pursuance of section 223, A is bound to compensate B. That means, agent B is entitled to be reimbursed from the principal A because he has instructed him and agent acted in pursuance of the direction given by the principal and so is entitled to be reimbursed. So, that is why by discussion it is clear that section 124 of the definition of the contract of indemnity is narrow, because there are other aspects which I have discussed in section 69, 145, 222 and 223 of the Indian Contract Act. So, that is why it is said that the definition of the contract of indemnity is narrow one, and so there are various limitations.